As you know, one of the biggest problems we have when we go around talking on the radio or doing seminars or things of this nature is we have some very passionate people come up with their, you're not talking about this, it'll be like the Federal Reserve or the corporation thing or the original 13th Amendment. We're going to start debunking a couple of these. One is because it's a waste of time to be on talking about an issue or thinking something's an issue that's really not. And we need to get people focused on the real issue. And so we're going to start with this real popular thing. You can get on the internet, you can find this the missing 13th Amendment. The original 13th Amendment, the titles of the Nobility Amendment. Basically, it's an amendment that was proposed in 1810, if I'm not mistaken. And it says this, I'm just going to read it. It says, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. So what you see is the concept of what the Patriot community says is if any citizen of the United States, at this time, this is not a 14th Amendment citizen of the United States, this is a citizen of any one of the several states, shall accept a title of nobility or something from some king, emperor, prince, or foreign power, two things happen. Is they're incapable of holding office and they lose their citizenship. And the way this is tied in, of why it's such an important amendment, is the Patriot community holds the title of Esquire, which a lot of attorneys use. David Johnson Esquire. That is a title of nobility. It comes from the British bar, and that they're incapable of holding office. I don't really hear them say that they shouldn't be citizens. But if you think about it, actually thinking about it from that concept, if all lawyers are forbidden to be citizens, then how do you
how do they even
get defended? Yeah,
law?
I mean, so we got one weirdness right there. If that's the proper interpretation of Esquire being a title of nobility, but the concept that's most often bantered about is that it's supposed to prevent attorneys from holding office. That's one of the biggest problems we have in this country is attorneys holding office, and that this amendment by attorneys being esquires, being beholden to the crown, that when this amendment was proposed, this is one of the things that incited the War of 1812. The crown did not want this to happen. They wanted to be able to have their attorneys in our government. And so they started the war and they came to Washington. We know about Washington, D.C. being burned down by the British, that it burned down the archives, burned down the records. And so this amendment, after it had been ratified or was close to being ratified, it just disappeared and everybody just swept it under the carpet.
Okay.
It didn't really happen. Let's go a fuzz into the history of who found this. Basically, this came from a guy by the name of David Dodge.
Okay.
And in 1983, he was doing some research at a library in Maine. He stumbled across this Constitution of the United States printed in 1825. And in this Constitution of the United States, the 13th Amendment is actually printed as if it's a part of the Constitution. So the big aha goes on. He starts doing the research, and he says that it took 13 states to amend it. The 13th state was Virginia. They amended it in 1819. It should have become part of the Constitution, and it's been swept under the rug. So that's the general concept of it. Well, let's just look at this. Okay, this amendment was proposed. Let's see what the Constitution says. The Constitution says that Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution. So that tells you how many states have to be part of proposing an amendment.
Okay.
It's 2/3. Okay. Then it goes on, and it says, blah, 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 shall be valid for all intents and purposes as part of this Constitution, this proposed amendment shall be part of the Constitution when ratified by the legislatures of 3/4 of the several states or of conventions. Okay. So now, it's proposed by 2/3, it has to be ratified by 3/4 of the states, a proposed amendment to the Constitution. Well, let's just do the numbers here. On December 10th, 1812, there were 18 states in the American Union. Okay. 12 states had ratified by this date, okay, and 4 states had already voted against the amendment. And those states were New York, Connecticut, South Carolina, Rhode Island. They'd voted against it. So that left us several that hadn't made an action on it. So again, we have 18 states in the Union. What's 3/4 of 18? You need 13 and a half. Well, what's that break down numerically as a fraction? Well, it's 0.722. Okay? And 3/4 is 0.75. So if you get 13, have you reached 0.75 yet?
Not quite.
Okay, so he's using the method of, well, we're going to round up. Okay, well, that's controversial in and of itself. So is the magic number 13 or is it 14? I would say realistically it has to be 14 because that's, you reach it on the 14th. The 13th has not reached 0.75. Hasn't done it yet.
Okay.
Okay. When Virginia became the 13th state to ratify, again, they're using the magic number 13. I'm saying it should be 14. Then it became part of the Constitution. 13 states have ratified it. Here it is. Well, they ratified it on March 12th, 1819. Well, now we got to refigure some things. Well, how many states were in the Union when the 13th state had ratified it? Well, by this time, there's 21 states in the American Union. Okay, so now it takes...
the requirement grows a little bit.
Now the requirement, now the 3/4 requirement grows to 15.
Okay.
Okay, so now they did get the 13th, but technically, now they got to have 15. Well, this was presented to Dodge. And what did he say? He came back with this concept. He says Article 5, which we read of the amendment process of the United States Constitution, is silent on the question of whether or not the framers meant 3/4 of the states at the time of the proposed amendment is submitted to the states for ratification, or 3/4 of the states that exist at some future point in time, since only the existing states were involved in the debate and vote of Congress on the resolve proposing the amendment. It is reasonable that ratification be limited to those states that took an active part in the amendment process. So what he's saying, what he's arguing here is that, well, there were only 18 states in the American Union when it was proposed. It was 2/3 of them. And so ratification belongs to only 3/4 of the ones that were in the Union when it was proposed. Okay. So if the Union grows, it's not binding on those other states aren't really full members of the Constitution or of the Union.
But it still affects them.
But it would still affect them. See, it becomes an absurdity.
Okay.
It doesn't make sense.
Make any sense.
And he goes on, and he also gives some evidence by James Monroe, or President Monroe. He had a Secretary of State ask the governors of Virginia, South Carolina, and Connecticut in January of 1818 as to their status of the amendment. Dodge says by President Monroe sending it only to the states that were in the Union when it was proposed, and not the new states that were added later, which were Louisiana, Indiana, and Mississippi, and Illinois. He is indicating that they didn't have a voice. So he's using that as evidence. It's because Monroe didn't send letters to them on their status that's also evidence that it was only binding on the original 18 rather than the 21 states that were.
Well, why would he only send letters to just those particular states?
Two things. One is I haven't researched to see if that's an accurate statement yet.
Okay.
I mean, did he leave them out? But number two is what difference does it make? I mean, there's no legal precedent in who a president sends letters to.
Oh, okay.
But so what we want to do is say, well, has this type of thing happened in the past? And I would say, well, absolutely. I mean, you've got the 27th Amendment. The 27th Amendment was proposed in 1789. It was one of the original Bill of Rights, the 12 amendments that were proposed at the outset of the country. 10 were ratified. We know them as the Bill of Rights, the first 10 amendments. Well, one of them actually ended up getting ratified in, 1992, May 7th, 1992. Okay? So an amendment that was proposed when there was only 13 states. Actually, there's only 1789. North Carolina didn't come in until November of 1789, right? Actually, I think there might have only been 11 states in the Union. We'll look at that up. But you have an amendment that we'll say between 11 or 13 states when it was proposed, the Bill of Rights were proposed, so it would only take, 7? It would only take 8 states, maybe 9 states. Well, then how come we didn't consider that one ratified till 38 states had ratified it? Okay, so again, we haven't used that process that it's only binding on the original ones that were there.
Traditionally, if they come into the Union, they're
also
member. Part of it.
You become a full voting member.
Yeah.
Otherwise, other people are imposing laws on you that you don't have a voice in.
Yeah. Well, that makes sense.
I mean, it's kind of absurd.
Okay.
So, I say that this concept of the original 13th Amendment, it's total, the numbers don't add up. If people will do the research and just quit reading on the internet and getting all excited, if they would do the research, you'll find that this is a waste of time argument.
You've looked a lot of those up before. I mean, you've seen on the internet where the results of all these, where different gurus are talking about each thing.
Absolutely. It's been out there. This concept has been out here for well over 15 years. Well, heck, he started at, 93? So, 93, I mean, almost 20 years, 19 years, this has been festering in this country. Of this has been a problem.
Wow.
And this one's out there is tenacious, that the United States is not a country, it's a corporation. And it's everywhere. And they talk about this Act of 1871.
I hear this a lot, this one.
And it's all over, and all you got to do is plug it into the internet. I'm going to throw a couple of them up here, some of the internet research out there. Here's one, and it basically says, 1871, February 21st, Congress passes an act to provide a government for the District of Columbia, also known as the Act of 1871. And the commentary says this: with no constitutional authority to do so, Congress creates a separate form of government for the District of Columbia, a 10 square mile parcel of land. So they're saying that they created this government. Now, what do they say this government did? It says, and they go on with commentary, the United States isn't a country, it's a corporation. In preparation for stealing America, the puppets of Britain's banking cabal had already created a second government, a shadow government designed to manage what the common herd believed was democracy, but what really was an incorporated United States. It says Congress had no authority to do so, created a separate, or with no authority to do so, created a separate form of government for the District of Columbia. I'm trying to get to where she adds that it was a strategic maneuver by British and European interest, international bankers intent on gaining a stranglehold on the coffers of America. And so they're talking about this Act of 1871. Here's another one. You got Godlike Productions. They put it out there. They got other issues. In 1871, the United States Constitution was suspended in favor of a Vatican corporation. So they're talking about this Act of 1871, created this Vatican corporation. Here's another one. Before it's news, the United States isn't a country. So it's all over. That's the Vatican. It's the Crown. And you can go through these things. But let's just go to, they say that Congress passes legislation over the district without any authority whatsoever. Well, Article 1, Section 8, Clause 17 of the Constitution says, and this is what Congress has the power to do. Congress can to exercise exclusive legislation in all cases whatsoever over such district. They're given the authority to pass exclusive legislation over this 10 square mile. So that debunks the opening sentence of virtually every one of these arguments. They pass this legislation over the district with no authority whatsoever. They're actually given
authority right there.
They're given authority. So that's debunked right there. Number two is that every constitution is a corporation. I mean, what is a corporation? A corporation is a piece of paper. Okay, it's you and I have an idea that we want to become a corporate body of some sort, and we want to go by certain rules, kind of like can be a little contract here, and we're the corporate body. But what can the paper do? You know, can a paper be sued? Can a paper pay taxes? Can a paper build a Walmart? Can the corporate papers of Walmart build a Walmart? Well, no, they're papers. They sit on a shelf. What makes a corporation alive is the people that are parties to it. And so I'm just going to read out of Bouvier's corporation. It says corporation, and this is 1856. It's an aggregate corporation is an ideal body created by law, composed of individuals united under a common name, the members of which succeed each other, so that the body continues the same, notwithstanding the changes of the individuals. Of course, we elect our individuals into the corporate bodies of government, but the state of North Carolina, the United States government, continues on, whether George Washington is president or not. You know, it's not based on who's there. It's the officers that fill in the corporation.
Okay.
It says that, and which for certain purposes is considered as a natural person. A corporation is a natural person. You can tax it. You can fine it. You can, sue it. Okay.
So it gives it certain aspects that kind of make it like a person.
Right. And this is another concept people have is that a corporation is a human being. Well, it's not. It's given these things. It's been for hundreds of years. Given the corporation is given the status as a natural person so that it can be sued, so that it can be
Certain
taxed.
things apply to it.
Because I cannot get money from a piece of paper, corporate
Okay.
paper.
Yeah.
Okay. It says a corporation or body politic or body incorporate is a collection of many individuals united in one body under a special denomination having perpetual succession under an artificial form and vested by the policy of the law with the capacity of acting as, in several respects, as an individual, particularly in taking and granting property, contracting obligations, and of suing and being sued, of enjoying privileges and immunities in common, and of exercising a variety of political rights. Again, political rights. More or less exclusive according to the design of its institution. Huh?
More or less extensive.
More or less extensive. Or the powers conferred upon it either at the time of its creation or of any subsequent period in its existence. And it says corporations are divided into public and private. Again, this is the same definition. And it says public corporations, which are also called political and sometimes municipal corporations, are those which have for their object the government of a portion of the state. And although in such cases it involves some private interest, yet it is endowed with a portion of political power, the term public has been deemed appropriate. And then it goes into nations and states. So you got public corporations, and then nations or states are denominated by publicists, bodies politic, and are said to have their affairs and interests and to deliberate and resolve in common. They thus become as moral persons. Again, the United States Constitution cannot attack Germany. It's the people. Okay, so the United States, organized under there, acts as a moral person. We can go and defend ourselves. We can go liberate people. We can do things. We act as a moral person, having an understanding and will peculiar to themselves, and are susceptible of obligations and laws. And it says, in this extensive sense, the United States may be termed a corporation, and so may each state singly. Well, this is 1856. And again, they're talking about this act of 1871. So in 1856, it was the understanding that the state governments are corporations, the United States government is a corporation, and so it was
already defined well before any of this stuff even came
well before all that. Okay, let's look at this. Here's the actual act of February 21st, 1871. The one that they're saying that the United States was changed from a country to a corporation. And you'll also see that we went from the United States, the Constitution of the United States, to the Constitution for the United States. They say that it created all these different things when you read these websites. Well, what did it create? What was the name of its creation? Well, the opening sentence of this act, and the act is titled, An Act to Provide a Government for the District of Columbia. And it says, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all that part of the territory of the United States included within the limits of the District of Columbia be, and the same is hereby created into a government by the name of the District of Columbia, and by which name it is hereby constituted a body corporate or for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal and exercise all of the powers of a municipal corporation not inconsistent with the Constitution and laws of the United States and the provisions of this act.
It's like they just quoted the definition we just read.
Yeah, which again, nothing different. There's no conspiracy behind this. So what are they doing? What's Congress doing here? Okay, who has the authority to pass exclusive legislation over the District of Columbia, that 10-mile square?
Congress.
Congress. Okay, so they've got
the Constitution.
As defined by the Constitution. Well, so who's responsible for sweeping the streets, collecting garbage, having the streets paved, having a fire department? Who's responsible for all that? Congress. Okay. Does Congress want to do that? These guys want to come into Washington, and then when their session's over, they want to go back to their respective states. So what are they doing here? They're creating a city government, a mayor, to where, it's just a city government. They can manage it. They're their own distinct thing, but they can't operate outside the Constitution of the United States, And it's nothing more than making a municipal corporation, just making a city, making a city corporation that they manage it. Congress doesn't have to deal with it. And so this huge myth that this act created a change in the fundamental law. We got Americans seeing that the Constitution's overthrown. We're in a different place. You know, we're not operating by it. And it's like a magnet. If you got, we say the point in time is the Reconstruction Act, and you've got this magnet, you know, facing up, and then you got an opposing magnet that wants to be repelled by it. And you got everybody in America, and they're going to say, oh, the issue is, oh, bam, it clicks right here. The magnet hits right here. Oh, that's the progressive. It's Teddy Roosevelt. They started all the problem. Then you get the people who say, oh, no, it's the Act of 1871. And we're saying, well, no, it's the Reconstruction Act. And you put that magnet over it, and it's like, whoa, it won't stay there. It wants to hop over here. You know, it's over here.
But the actual issue.
And then you got people say, well, George Washington didn't take a legitimate oath, so it's over there, and it sticks over there. Or, you know, it's the 13th Amendment. It'll stick. But okay, no, it's Reconstruction.
It's like the giant elephant in the room, because I mean the Civil War is pretty hard to miss, and that whole area, from everything I've learned about it, the Civil War and Reconstruction was this huge thing, surrounded by controversy, and yet we want to attack the fact that we're a corporation. Which really, even if we fix that, what would it do? I mean, you know what I'm saying? Like even if everything that they were saying was true and they fixed it, what great good would it do? What would it accomplish?
Well, logically think about it. They say the problem happened in 1871 when it became a corporation. Okay? Well, in 1868 they made all state citizens citizens of Congress. So do they even need to incorporate and make a new constitution when Congress already has total control over them by the Reconstruction Act?
They don't even need that. Yeah.
They don't need it, you know, 3 years later.
Yeah.
So it doesn't even fall on a timeline to what would actually, if they got us out from being a corporation, let's say they annulled the Act of February 21st, 1871, and it's gone, everyone's still a United States citizen. We're still not state citizens. We're still conquered by the United States. We're still subjugated with benefits. Let's just do the individual sovereignty. That you can be an individual sovereign. I only want to say about 2 sentences on this. Is there has never been any such thing. There's no such thing as people in the United States being individual sovereign. It's the body politic. It's the people carry the sovereignty, not the individuals. And so this is just another, you know, concept that we run across all the time. We totally rail against this concept of individual sovereignty.
These are the people that call themselves sovereigns.
The sovereign citizen movement.
Citizen.
I'm a sovereign citizen. I'm a law unto myself. I get to do what I want, and I was granted that by, you know, the Supreme Court in a ruling that says in the United States the people are kings or something of that nature. And so they take one thing out of context, and all of a sudden they get this whole philosophy built out of it, very similar to these philosophies, previous philosophies we just went over.